solution. Before we begin the arguments for this morning, I'd like to inform the members of the bar of a very unique initiative of the Supreme Court. Before we begin the arguments for this morning on combating I'd like to inform the members of the bar of a very unique to assist judges and the legal community in identifying, understanding, and combating stereotypes about women and legal discourse. It contains a glossary of gender and the legal community in identifying, understanding, and combating stereotypes about women in legal pleadings as well as orders and judgments. It contains a glossary of gender unjust as well as judges and suggests alternative words or phrases. The handbook identifies drafting stereotypes about orders and judgments, many of which have been utilized by courts in the past, and demonstrates why they are inaccurate and how the handbook identifies common stereotypes about women. The intention is not many of which have been utilized by courts in the past, but merely to show how why they are inaccurate and how they may distort the application. To raise awareness against the utilization not to criticize or cast doubt, particularly those prejudicial merely to show how stereotypes the handbook aims to explain what stereotypes are. To raise awareness against the utilization of harmful stereotypes, particularly those prejudicial to women, identifying language. The handbook aims to explain what stereotypes are and helps judges identify and avoid such stereotypes by firstly identifying common reasoning patterns that are based on gender stereotypes, particularly about women, and discussing why they are incorrect, and two, identifying common reasoning patterns that are based on gender stereotypes, particularly about women, and discussing why they are incorrect, and three, so it's highlighting binding decisions of the Supreme Court of India that have rejected the first page of the document here on the screen, by judges and it's uploaded. It will be uploaded very shortly in a minute or two on the website of the first page of the document here on the screen. And it's uploaded on the website. It will be uploaded very shortly in a minute or two on the website of the Supreme Court of India. We've also, in a couple of days, we'll be also uploading on the website right now video tutorials, the manual on how to do e-filing for members of the bar who just require a little bit of. In a couple of days, we'll be also uploading. So that's all. Simple video tutorials site in a minute on how to do e-filing for members of the bar who just require a little bit of hand holding on that. So that's all. It should be here on the website in a minute now, or a few minutes. That's fine. Yes. Thank you, Dr. Krishna. Yes. No, but Mr. Dwivedi, if you start using it, you'll find it so simple actually. No, but Mr. Dwivedi, if you start using it, you'll find it so simple actually. Please do answer them in your submissions. No difficulty. Addition, you will know. We are making notes. So you can always make the addition in your oral arguments. Mr. Addition, you will know. Mr. Dwivedi, I'll give you. We are making notes. So you can always make the addition in your oral arguments. Formulating a judgment. We are still now. It's almost done. Mr. Dwivedi, I'll give you whether a child born from a avoidable marriage, formulating a judgment, we are share in the ancestral property. Almost done. So today, over the last few days, as to whether a child born from a avoidable marriage, we didn't have any such limit as we have now imposed the ancestral property. 3 or 4. So today, over the last few days, I've opened the file. 3 or 4 compilations by each member. We didn't have any such limit as we have now imposed here. It's impossible to sit down to dictate a judgment because you have by each member of the bar. Judgments of different genres, compilations by each member coming up and. It becomes impossible for the judges to write judgments. Judgments of different genres and different submissions coming up. Now look at all the judgments. It becomes impossible for the judges to put them in chronological write judgments. So even then it doesn't help because you marked what was being read out by the lawyer. Look at all the judgments, prepare a separate file, put them in chronological order. But even then it doesn't help because you have marked what was being read out by the lawyer.
In such large volumes.
So, this is the real problem which we face.
The concept of giving written synopsis was comparatively not there. Everything used to be argued, we used to take down notes and dictate. Now, the purpose of a written synopsis was comparatively, as I understand, is not there. Facilitated argued, we used to take down notes and dictate. Instead of that, it becomes so much more cumbersome that we don't know who is saying what. As I understand, these kind of pleadings facilitated the pages used to not be filed. Instead of that, it becomes so much more cumbersome that we don't know who is saying what. There are many cases of these kind of pleadings of thousands of pages used to not be filed. At rethinking, they are certain.
Devedi, my take on
There are
this
many
has
cases of
been,
this category.
if the homework in the office
no,
is
no.
thoroughly done,
At rethinking,
normally
they are
this
certain.
problem doesn't arise. Devedi, my take on this has
It is
been,
possible to do.
if the
The
homework in
judgment
the
can never be
office is
complete.
thoroughly done, normally
See,
this
the
problem
judgment can
doesn't
never be
arise.
complete. That thought process will continue
It
from
is-
your
it is
side.
possible.
It will continue from our side. The judgment
My
can never be
fear
complete.
always is the judges that in this process,
See, the
I've missed
judgment
out
can never
some
be
very
complete.
important
That thought process
point
will
of judgment
continue
because
from your
it's all,
side.
you know,
It will continue from our side.
silos. Fear always is the judges that in this process, I've missed out some very important trying and collating can always do that. Can tell our law clerks to put all the judgments together. And that's what is really worrying for us as judges. You feel that, oh my God, reading, trying and collating can always do that. Can tell our law clerks to put all the judgments together in a chronological order. Danger is you feel that, oh my God, I might just miss something because things come in, driblets over a period of time. Supreme Court gives 30 minutes time and 1 hour's time. So we need to now just...
The US Supreme Court do it in 30 minutes. The most complicated case, they
Supreme Court
only
gives
hear
30
you for
minutes
30
time
minutes.
and 1 hour's time. So we need to now just...
The US Supreme Court do it in 30 interventions of the court. The most complicated case, they only hear you for 30 minutes.
No, we are far more
Including
advanced
time
technologically.
interventions of the court.
Actually, trust me, we are almost at the high end of the curve in India. No, we are far more advanced technologically. Actually, trust me, we are almost at the high end of the curve in India.
Part of habit action.
Yes. So that we can just keep it on the dais, as the hearing. That will be very useful. Naika Bhushan. Yes, that you want to refer to them? Yes. So that we can just keep it on the dais. Again, refer to. That's very useful. Oh, you have also put it in a plastic. Again, refer to. That's very useful. Oh, you have also put it in a plastic. Oh, excellent. Yes, Dr. Lava.
No library talk this time, my lord. But start again, my lord. I appear for the JK People's Conference. No library talk this time, my lord. In writ petition 1165. Start again, my lord. I appear for the JK 2019 Conference. A question that your lordship in writ petition 1165 challenged the presidential of 2019. Proclamation of 19th December. A question that your lordship we've challenged the suspension, my lord, and that is very important to our argument on Article 3. Proclamation of 19th There December. Is also another petition. We've challenged the suspension, my lord, and that is very important to our argument on Article 3 of 2019. There is also another petition actually challenges the proclamation. Sohail Qureshi 1068 2019, which actually challenges the proclamation.
2068, right?
1068.
Yes.
Now, my lords, I would begin by saying, as well from my Lord the Chief Justice, that this oral submission is in the nature of a dialogue. I would and a very important dialogue, which well even the US Lord the Chief Justice doesn't have. That this oral submission is in the nature of a dialogue, question and answer, and that's a very important dialogue. And it is because of the nature of the dialogue doesn't have. We have to, on an ongoing basis, answer a bit of question and answer, and that's it. And it is because of the nature of the dialogue, my Lord the Chief Justice on an ongoing basis answer to what fell from your lordships as well. I'll give your lordships an example. Of course, there are Chief Justice made a reference, but nevertheless, my Lord, that 249 is very, very important. Of course, there are different John to build the diversity argument. And whether there is transformative question is very, very important. Whether there is for us a basic structure to build the diversity argument, that's a lost cause, and whether there is transformative. Then, my Lord, your lordship should ask questions whether there is a basic structure. And whether that's a lost cause or not. Subclause then, my Lord, your lordship should ask questions. Now, this is important because it's been used only twice. And whether it was used in Geo 44 subclause 3 survives. And now it has been used this is once again because it's been used only twice. 73. It was
Now,
used
if it
in
doesn't
Geo
survive,
44.
my lord,
How can it be used?
and
in
now
this
it has been
particular
used
way?
once
We have
again
to answer that
in
question
Geo
to your lordship.
273.
In addition to that,
Now,
my
if
lord,
it doesn't survive, my lord,
there was
how can
seems
it be
to have
used
been
in this
some
particular way?
we have to answer that
Confusion or
question to your lordship.
misunderstanding
In
on the
addition to
status
that,
of
my lord,
merger agreements, my lord.
there was
The
seems to
question that
have
fell
been
from your
some
lordships was
confusion
that
or
once the instrument
misunderstanding
of accession
on
is
the
over,
status of merger
sovereignty
agreement.
is complete. The question that fell from
Our
your
respectful
lordships was
submission, my lord, on this
that
which I will
once the
elaborate.
instrument of
I've done it
accession
in a
is
note,
over,
my lord.
sovereignty
Like
is
Mr. Zafar,
complete.
I'll hand over that note, my lord, to your
Our
lordship.
respectful submission, my
Lord,
lord, on this which I will elaborate.
37, I've done it in a
As
note,
far as
my
the
lord.
instrument of
Like
accession
Mr.
is
Zafar, I'll hand
concerned,
over that note, my
it
lord, to your
deals with
lordship.
external sovereignty.
Lord,
Kindly
37,
bear this in mind, it's very
as far as
important.
the instrument of accession
External
is concerned,
sovereignty is lost. It deals with external sovereignty. Kindly bear this in mind, it's very important. External sovereignty is lost, with a few exceptions here and there. With a few exceptions here and there. But internal sovereignty is not lost. That is why in Premchand, they say the monarch was still an absolute internal sovereignty is not lost. That is why in Premchand, they say the monarch was still an absolute monarch. So, what the purpose of the standstill agreement was, what system would you have in the meanwhile? So, what the purpose of the standstill agreement was, Raja of what system would you have in the meanwhile? Didn't sign a standstill. The records show there was some toing and froing and eventually, which means he retained all his power. Didn't sign as far as internal sovereignty. The records show there was some toing and froing and eventually, which means he retained all the powers of the Maharajas. And so, as far as internal sovereignty is concerned, the standstill was very important because all the powers of the Maharajas and the coming states, my lord, retain their merger agreement is important, my lord. Now come to the merger agreement. It finally indicates the external extent of internal sovereignty because it finally indicates the external there was no standstill agreement sovereignty. And if there was no merger agreement, my lord, the Maharaja would be absolute. There was no standstill agreement. And if there was no merger agreement, I take 370 to be, my lord, the Maharaja would be absolute, a constitutional substitute for a standstill in merger agreement. I take 370 to be, my lord, a substitute, my lord, a constitutional substitute for a standstill in merger agreement, my lord, later when I come to 370. Without which, my lord, we are lost. Your lordship also, my lord, and I have a question to Mr. Zafar Shah, that on the 4th of August, your lordship also, my lord, what were the autonomies that you were allowed, you were going to lose? That on the 4th of August, he promised you a list. What were the autonomies that you were allowed? I will indicate what these autonomies meant and what was lost for Jammu and Kashmir. He promised you a list, which comes back to Justice Paul's everything question. I will indicate what these autonomies meant and what was lost. The answer is no, my lord. Which comes back to Justice Paul's, and it has to continue to preserve, my lord, the federation and the conditions. The answer is no, my lord. The federation was created. It continues and it has to continue. So let me begin to preserve, my lord, what I began with the other day, the conditions under which the federation was created. That we have the greatest diversity. So let me begin with many continents with the other day, my lord. Take many countries, and that is that we have the greatest diversity. This diversity in the world, unparalleled. Take many continents together. That is why, my lord, take many countries. Professor Ravinder Kumar. This diversity what should I say in my Colombo lecture? He said, say that the Constitution of Ravinder Kumar, Constitution for a civilization. I asked him, I said, what should I say in my Colombo lecture? And many countries. He said, say that the Constitution of India is a constitution. And this is what makes our Constitution more exciting than many nations and many cultures. And this is what makes our Constitution more exciting. I was taking your lordships to. On the question of diversity, I was taking your lordships to just reading it. Where is the other note? I have, my lord, done a list which I'll give to your lordships, my lord. Just reading. But I was going to invite your lordship's attention to I've, my lord, done a list which I'll give to your lordships, my lord, but I was going to invite your lordship's attention to Article 3 first. All of Article 3, my lord. But I'm going to read one important aspect of it, my lord. And that is the proviso. But I'm going to read one important aspect of it, my lord. That before anything is done under Article 3, the proviso, which says it is mandatory for the President under Article 3 to refer the bill to the legislature. Mandatory. It is mandatory for the President before you invoke to refer the bill to the legislature. Mandatory. It's a condition precedent before you invoke Article 3. Just as there are conditions in Article 370 which have to be fulfilled by condition precedents. Just as there are conditions in Article 370. Now on Article 3, my lord, which have to be fulfilled by condition precedents. Now on Article 3, my lord, of 19th December, virtually created an amendment of Article 3. Proclamation of 19th December virtually created an amendment of taking the condition precedent out. Why, Mr. Sybil read all that to you, but I want to refer your lordships, my lord, taking the condition precedent out of the proclamation. Mr. Sybil read all that to you, but I want to refer your lordships, my lord, to that particular part of the proclamation. Your lordships will find this, my lord, my copy somewhere here. Like Mr. Dwivedi, your lordships will find this, my lord, what your lordship is doing. We just have to learn and catch up, my lord. This your lordships will find. Mr. Dwivedi, I have no problem in volume 3 documents doing. We just have to learn and catch up, my lord. This your lordships will find. And in volume 3 documents.
Page 92.
I'll just give it to your lordships.
Page 92.
And the PDF, PDF 92. Now, my lords, I'll just give it to your lordship straight away.
Page 92.
And it's very important that we should. PDF 92. Now, my lords, I want to take your lordship straight away. And it's very important that we should.
Sanjay Miller. Page. Page. Ultimately, everything boils down to this. Of course, the Constitution itself, and but so far as documents are concerned, ultimately everything boils down to this. In case something is missed, you can tell Constitution itself, Dr. Dhawan's instructing advocate. So far as documents are concerned, in one page now we have. In case something is missed, you can tell Mr. Dr. Dhawan's instructing advocate. They'll just put it in and
divine fire.
What do we call this? This plastic made up.
Divine fire.
Your Lordship will see that there is a condition precedent in Article 3. And this condition precedent, my Lord, was added to by CO48 condition precedent in Article 3. And this condition precedent, my Lord, was added to by CO48, which I'll show to your Lordships in a moment, my Lord, which further required the bill to be sent to the legislature of the state, but we're not concerned with that because it has to be sent to every single state, which further required the bill to be sent to the legislature of the state, but we're not concerned with that because it has to be sent to every single state. C subclause 2. This notification, C subclause 2. So much of the first proviso of Article 3 of the Constitution as relates to the reference by the President to the legislature of the state, and the second proviso to that of the Constitution, so that much as relates to the reference by the President to the legislature of the state of the Constitution, and the second proviso relates to laying before the legislature much of clause 2 of 151 of the report, which is about submitted by the Governor to the Controller, Auditor General. You will see that the opening sentence is the following provisions are suspended by the Governor to the Controller, Auditor General. You will see that the opening. In other words, my Lord, a mandatory provision of Article 3, whether it applies to Kashmir or elsewhere, my Lord, in other words, is suspended. Mandatory provision of Article 3, whether it applies. It's not a question of just laying before Parliament as a substitute. Article 3 and Article 370 does not tolerate substitutes. It's not a question of just laying before Parliament as a substitute. Article 3. Now, my Lord, what does this do? This is not, my Lord, that can be done under a proclamation. Now, my Lord, what does under this 356? Do? This is not. It is a constitutional amendment which is subversive of the Constitution itself. If this suspension fails, my Lord, President's rule will fail. And its extension, my Lord, in July will also fail. You have amended the Constitution, albeit to all states and certainly to Jammu and Kashmir. And this mandatory provision takes us to the core of the mandatory requirements, my Lord, of Article 3. Because the entire JK or Reorganization Act emanates from Article 3 and Article 4. Take away this condition, my Lord.
How do we deal with this Article 356(1)(c)?
Sorry, my Lord.
Article 356(1)(c) says that if he may make a proclamation where a situation has arisen that the government cannot be carried on in accordance with the provisions of this Constitution in any state, and then C.
Make such incidental and consequential provisions as appear to the President to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any provision of this Constitution relating to any body or authority.
So the President has a power to suspend certain provisions of the Constitution during the operation of a proclamation under 356.
The suspension in this case goes beyond supplement, my Lord. It goes to actually taking out a mandatory provision. Of course, my Lord, Article 4 says that any change that is made will be treated as not requiring an amendment. But leave that aside, my Lord. How is 3 and 4 to operate after this? The presidential duty, my Lord, has to be a little more careful
Because this was tailored way back in 19th December 2018 to start a process, my lord, of amending the constitution for the purposes of which
Normally when the legislature, here of course it's the constitution, uses the expression means and includes. Here it's not means, but it says make and includes. When means and includes is used by the legislature, it's an indication of expanding the power. So when the constitution says, it begins by saying make incidental or supplementary provisions,
yes,
and then says including. So this including seems to be to widen the ambit of what was stated earlier. Namely, the earlier part says you will make incidental or supplemental provisions. But then it says including. So including would mean that what was otherwise not a supplemental or incidental provision is within the ambit of the presidential proclamation, isn't it? Because suppose the clause C read just up to proclamation and didn't have and including. It's not and including, it's including.
That's right.
Suppose it ended with the word proclamation.
The operation of any provision of the
So
constitution.
if the last part of Article 356(1)(c) was not there, you could have challenged any amendment of the Constitution on the ground that you don't have the power to make an amendment of the Constitution in the guise of making an incidental or supplemental provision.
Lord, this is the basis of our challenge, my lord. In our petition, we have challenged only the suspension.
My question is this. Suppose the President in a proclamation suspends the operation of any provision of the Constitution. Is that amenable to a challenge on the ground that it is not incidental or supplemental? Or are these words of widening the ambit of the first part of 356(1)(b) so as to be immune from such a challenge?
This, my lord, has remained within the limits of 356. That is, for the governor, you read the president. For the legislature, you read the legislature. But I've never seen a provision in any proclamation, my lord, throughout, my lord, these decades, which actually uses the supplemental and including. I've never seen it take away a mandatory provision of the Constitution. This is exceptional, my lord. Now you can read it together in one way, you can read it together in the other way. If you expand 356(c), my lord, then you will say that the president has a carte blanche to amend any part of the Constitution as part of the supplementary provisions.
Can you, for example, say that there'll be no judiciary in the state?
That's right, my lord.
That's what you're
That may be covered by the proviso, but at any
right.
rate.
Oh yes, the proviso says, of course.
Supplementally, this 356(c) has to be read with the mandatory provisions which it cannot dilute.
But actually the proviso, Dr. Dhawan, the proviso seems to indicate that if Parliament, if the Constitution wanted to exclude a particular power from the authority to suspend a provision of the Constitution, then that has been specifically defined. So the proviso says that you will not suspend anything pertaining to a high court, or you will not assume to yourself as the president any of the powers which are vested by the Constitution in a high court during the operation of a proclamation under Article 356. So where it wanted to introduce a restraint on the presidential power, it has done so in the form of the proviso.
Right.
Do we now say that, well, apart from the proviso, there may be certain other parts of the Constitution which the president cannot suspend?
No, that is,
or would that be reading into Article 356 words which are not there?
not
Just one. I think coupled with the words appears to the president to be necessary or desirable for giving effect to the objects of the proclamation.
yes.
So there has to be connect and a nexus with the object of enforcing the proclamation. That's a restriction.
It must relate to 356. In other words, whatever is required to materialize 356, it must be related to that. And therefore, my lord, these words necessary or desirable are not carte blanche powers of the president. Could he have, under these provisions, suspended Part 3? It has been done, my lord.
Part 3?
That fundamental rights, directive principles. Could he have done all that, my lord? Therefore, my lord, it has to be given, even with the caveat of regards the High Court, it has to be given a limited meaning where your lordship finds that in every state that has been created under Article 3 and 4, this has been treated as a mandatory provision. There is a caveat that your lordships have imposed on Article 3 and 4, that all that it requires is a reference to the legislature, and the union is not bound by it. Those, my lord, when I come to my written submissions, I'll run through them very fast because I don't need to, my lord, take out the books or refer to the cases. This, to my mind, my lord, taints the entire process. Gopal Shankar Narayan, my lord. On the inclusion provisions for suspending in whole or in part the operation of any provisions of this Constitution relating to any body or authority of the state. And then a colon. This further subscribes the extent of the presidential proclamation. Otherwise, my lord, 356 is an exception. It overrides federalism. It collapses democracy in a state. Because if the presidential proclamation does something that is irreversible, and that is a test your lordship will use. And Justice Khanna is right, my lord, when he emphasizes necessary or desirable. In relation to body and authority, as I pointed out. If this proclamation is bad, then its extension, my lord, in July is also bad. Because that was a parliamentary extension for a further 6 months.
Yes.
Now, my lord, Article 358 suspends Article 19 during the proclamation, not beyond. This is now, my lord, and your lordships will see that further when I present CO 272 and 273. They go well beyond the period. And the genesis of all this, my lord, is the presidential proclamation. Even assuming, my lord, it goes for 1 year, it takes away conditionalities which cannot be taken away. Later, my lord, I'm sorry. I'm a little loud. I'm not used to whispering into microphones, like my predecessors. Now, my lord, I'm going to place. No, classrooms are very soft. Classrooms are a wonderful exchange with students, unparalleled, just as this is an exchange between the bench and us, my lord. And it is the nature of this exchange, my lord, that we must honor, under limitations of time, of course, my lord. But we must, my lord, honor this exchange as the most important part of arguing in this court. Now, my lord, in Article 3, CO, just want to point out the CO number. My lord, your lordships will see that because your lordship raised the question, what did you lose on 4th August, after 4th August? The CO 48, the PDF is 485. PDF 13, my lord. Take it out there. Going to have nightmares about PDFs, my lord. Now, my lord, if your lordships were to come to page 10 of volume 3, 406, sorry, not external, and PDF? PDF 13.
13. Same volume.
Same volume.
1954.
This is the
1954.
54 order. My lord, in a sense, the 54 order and 370, my lord, represents the constitution as relates to Kashmir. They were brought in by the Constituent Assembly. Now, I'll just read out that particular portion, my lord. so that I complete the 3-4 argument before I go into the business of how elaborate our constitution is. At the bottom of that page, my lord, 406, provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of the state. It puts in a conditionality, my lord. Not just to circulate it, but a conditionality, my lord, emanating from the state itself. Now, whether all this can be wiped out by CO 272 and 273 is another matter. I'm going to make one further proposition, my lord, about President's rule. Lest I forget, I'll refer to it later, my lord, if I can. Now, my lord, the further proposition, which is a wider proposition, is this: that during President's rule, Article 3 and 4 and 370 cannot be invoked.
Article?
Cannot be invoked.
Article 3 and 4.
3 and 4, my lord. Why? Because they have conditionalities, my lord. And the conditionality is specific to the legislature of the state, to the government of the state. And the legislature becomes parliament. The governor becomes the president. Therefore, the conditionalities that exist in 3 and 4 and Article 370, neither Parliament, my lord, nor the president can be substitutes for the conditionalities that exist in Article 3, 4 and 370. You don't go through that process.
Dr. Dhawan, is such a broad proposition with regard to Article 3.4. Forget about 370 for the time being. May not be correct in terms of the language used of Clause 3 to 356. Let's hope it never happens, but in a given case, it can happen. There can be disputes between two states, and which is impossible to resolve unless the center steps in with regard to boundary or something. So broad proposition, if you're making a broad proposition like that,
I'm responding.
it's very difficult. It's very difficult to accept.
I'm responding.
Because we can be varied situations which we may not be able to postulate as of today.
Well, I'm making about a proposition about process and substitution. Because 370, subclause 1, my lord, has its discipline. Just as 3 and 4 has its mandate discipline.
Leave 370 for the time being, but a broad proposition that Article 3 and 4, the provisos can never be suspended in terms of Article 356.
My lord, the Parliament cannot be, and I'll show the debate when Amit Shah introduced this, my lord, in the Lok Sabha. Parliament cannot be a substitute for the legislature of the state. That's a very narrow proposition, my lord. I've been prompted, my lord, nicely. And when Mr. Sibal talked about the political uses and abuses of the Constitution, then Proclamation 19th December, my lord, is an abuse of the Constitution, and it would be a further abuse of the Constitution if we substitute for legislature Parliament.
Dr. Dhawan, there's difference between existence of power and abuse of power or use of power.
Of course, my lord.
So let's not confuse the two.
Sorry, my lord.
There's a difference between existence of power or use of the power or abuse of the power.
No, my lord.
So let's not.
There is a power, no doubt. Its exercise is equally fundamental. We can't wish away the exercise as being purely nominal in nature. Now, my lord, when Maharashtra was broken, in the judgments are all there in my written submissions. I'll take your lordship very fast through them. They said you have to refer whether you like it or not. Likewise, Punjab, my lord. You have to refer the bill to the legislature of the state. You can't self-refer it to Parliament. And the Constitution says no bill can be introduced, my lord. It's a complete bar, my lord, because we have to understand the limitations of President's rule. And this is one of the important, my lord, limitations, that during President's rule, you may have the power to do whatever you want in 3(4) and 370. But the process, my lord, are conditions which can't be substituted by simply saying the governor will now become the president and the legislature will become parliament. This process of substitution, my lord, is subversive of the Constitution.
Dr. Dhawan, can Parliament enact a law during the subsistence of a proclamation under Article 356 in exercise of the power under Article 246(2) or in respect of a state list item?
Look, they can pass a law, my lord. No doubt about that, subject to all the limitations that exist.
Right.
Except, my lord, there is, when it passes a law under Article 3 and 4, it must observe the conditionalities.
In other words, what you're trying to, your argument would be this, that while Parliament can exercise the lawmaking power of the state legislature during the subsistence
With all
of
its
the proclamation,
limitations.
yes, with all
The
its
state
limitations.
list comes to them.
The state list comes to them. But certain other functions of the state legislature, namely in terms of the first proviso, to discuss a legislative proposal for altering the boundaries of the state, or under the second proviso for giving consent, that power can't be assumed by Parliament.
Lord,
Because then we are creating an exception to the language. I mean, you may possibly argue that you have to create that exception to give a purposive interpretation to that provision. But this one part is very clear, that to accept your argument, we are then creating an exception to 356(1)(b). Because 356(1)(a) says that the powers of the state government are vested in the president or in the governor, as the proclamation would say, other than the powers of the legislature of the state. Then 356(1)(b) says, declare that the powers of the legislature of the state shall be exercisable by or under the authority of Parliament. So we will then, to accept your argument, we have to then hold, of course, maybe by a process of construction, that those powers which are referable to Article 3 and 4, which are powers of the legislature of the state, no doubt they are powers of the legislature of the state.
the difference between the legislative powers of the and the consultative and other powers of the legislature. If your lordship will see 357, my lord.
But it says, declare that the powers of the legislature of the state. Now, which are the powers of the legislature of the state? Not
Legislative powers.
no, not just the powers under Article 246, but it could be all the powers of the legislature of the state which are vested in the Constitution. Would that be not a more natural construction?
Take your lordships to Article 257, subclause 2. 357. Sir. (357)(1), my lord, declares that the powers of the legislature shall be exercisable by or under the authority of Parliament. It shall be competent for Parliament to confer on the President the power of the legislature of the state to make laws and to authorize the President to delegate, subject to such conditions as they may think fit, the power so conferred to any other authority. For Parliament or the President or any other authority in whom such power to make laws is vested under subclause A, to make laws conferring
and imposing duties or authorizing the conferment of powers and the imposition of duties upon the union or the officers and authorities thereof. For the president to authorize when the House of the People is not in session, expenditure from the consolidated fund of the state, pending the sanction of such expenditure by Parliament. More important, the law is to any law made in the exercise of power of the legislature by Parliament or the president or other authority referred to in subclause so and so, which Parliament or the President or such authority would not, but for the issue of the proclamation of 356, have been competent to make after the proclamation has ceased to operate, continue in force until altered or repealed or amended by a competent legislature. Which is the competent legislature? So, my lord, even as regards the functions of Parliament, they are specified
356 is not plenary in nature. It's important to understand that. It is the bane of the Indian Constitution, my lord. It's introduced again and again and again. In fact, the Indian Law Institute, I was reading the 1935 debates, my lord, where Churchill interjects and says, create the situation in every single province. Now, my lord, 356 has been used and abused to a point where there must be some discipline to it. It is certainly not, my lord, a power to amend the Constitution. Let's leave it there. Not transferring executive and parliamentary functions, that is the power to legislate alone, is the core of 356 and 357. There are many provisions in the Constitution, I have a list here, my lord, where legislatures exercise many other kinds of powers as well, my lord. Powers of election, powers of negation, powers of consultation. So it has to be limited, my lord. Otherwise, my lord, what happened in the 5th August onwards, my lord, can happen to any other state during president's rule.
Dr.
And that is why the broad proposition.
Legislatures exercise other powers. You said consultation. Which were the other ones? I just missed that.
My lord, I have a list here. Article 3, for example, my lord.
So how do we conceptualize those other powers? Consultation, you said you used that some phrase which I just lost. You said legislatures exercise other powers.
There are legislative powers which emanate from.
That's 246.
Article 245, which says subject to the provisions of the Constitution. And it's important, my lord.
What are the other powers that you said? You said consultative.
Article 3 is a consultative power to express views. Article 54 is the right to vote in presidential elections. JK was not able to participate, my lord, in the last presidential election. Article 80 is to elect members to the Rajya Sabha. Article 169 is to pass a resolution for the creation of legislative councils in a state. Article 171, 243M, my lord. I'll come to those because I want to go into the question of the diversity of the Constitution.
243M.
Then, my lord, 243M. Then, of course, most important, my lord, list of them, I'll give it to your lordships, my lord. I think it's better. But the important part is it's limited to the legislative powers. It certainly cannot amend the Constitution. Or I'm going one step further, or deprive the Constitution of its mandatory processual requirements. It's an argument about process and power. And this, in my submission, my lord, taints, my lord, also the extension of president's rule.
That
It was
point you have made,
done by Parliament, which I've already indicated to your lordships. This is fundamental, my lord, to how this process of diluting 370 occurred and how Article 4, my lord, eventually got used with all these incidental provisions, which were limited to legislative powers and none other. Now, my lord, I wanted to get back to the point that I started with, my lord, about the diversity of the Indian Constitution. I'll quickly take your lordships through it, because your lordship is concerned with how this diversity can be preserved. Bodoland, my lord, is mentioned in the Constitution. Nagaland has, my lord, and others have autonomous councils, which, well, I'll take your lordships through them. Now, my lord, if this can be done under President's rule, anything can happen. Yes, they look much. What I've done, my lord, to save time, is I've prepared a list of the articles that take us to diversity. I'll quickly run through them in the Constitution itself. I know your lordship doesn't like paper being handed over, my lord. But we can put it on the website, my lord.
This is acceptable because these are only articles of the Constitution.
Quite right, quite right. My lord, it saves time. Yes. It saves time. That permission is permissible. Because when your lordships didn't permit Mr. Sibbal to give supplementary submissions, I thought that's a harshness that might be imposed on handing anything over to the court. Now, my lords, come to Article 2, my lord. This is important, my lord. It's Parliament's power to admit to the Union new states on such terms and conditions as it thinks fit. This is very, very different, my lord, from the assimilation, my lord, of the princes, etc., into the Constitution. That is, you go through an instrument of accession, you go through standstill, you go through merger, which then determines what is really entered into. Of course, my lord, in Podial's case, the majority judgment of Justice Venkatachalaya takes into account the entire history of the negotiations and says that although the Constitution says one person, one vote, nevertheless we will permit reservations for Bhutias, Leptas in the south. In the context of that history, we will nevertheless permit it. And there were two dissents, my lord, by Chief Justice Sharma and Justice Agarwal. Now, Podial reminds us that these negotiations are important, even though it says as it thinks fit. 2A was removed, my lord, in the Constitution because Sikkim was given associated statehood first. Now, my lords, kindly come to 3, which I've dealt with, 3 and 4. Then, my lord, kindly come to a very interesting provision, my lord, when we were dealing with affirmative action. That's Article 35. Prepare a proper list and give it to me. Identify to be more. Now, this is a very interesting provision, my lord, relating to Article 16(3). I'll just read it, my lord, because it's important. Notwithstanding anything in this Constitution, Parliament shall have, and the legislature of a state shall not have, power to make laws with respect to matters in Article 16(3), 32(3), 33, 34,
or for prescribing punishment for those acts which are declared offences under this part. And Parliament shall, as soon after the Constitution, make laws prescribing punishment. Laws immediately. Now, here's a very interesting provision, my lord. In relation to affirmative action, the power of the legislature is taken away. To change this, my lord, would require an amendment to the Constitution. Two judgments have dealt with it, my lord, which have dealt with not Andhra Pradesh and Jharkhand, but we needn't go into that. Then, my lord, if your lordships will come to Article 164. Got it. All done. I pointed this out on the other day, my lord. These are safeguards, my lord, for the federal unity of India. As indeed was 370 for the federal unity of India. It is part of the basic structure of federalism in our Constitution. When I was formulating this argument, I was told their lordships might be averse to a basic structure argument, so don't make it too strongly. So I'll stay within my limits, saying these are limits that a Constitution has in relation to federalism. Now, 164, my lord. I've given your lordships a list. I'm going around the list where taking your lordships through the important provisions. Article 164. My lord, has a proviso. Provided that in the states of Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha, there shall be a minister in charge of tribal welfare who may, in addition to be in charge of the welfare of scheduled castes and backward classes or any other work. My lord, this, if it is to be changed, requires a constitutional amendment. Can't be done under President's rule saying we will have this minister or that minister. Then, my lord, if I may take my lords, my lord, to 168. Which empowers the legislature, my lord, much in the same way, my lord, as the JK Constitution empowered the legislatures. Article 169, my lord. 168 and 169. This relates, my lord, to whether there should be two houses in parliament or not. Finally, bear in mind, Jammu and Kashmir had a legislative council under its constitution. I'm reading, my lord, 169(1). Notwithstanding anything in Article 168, Parliament may by law provide for the abolition of the Legislative Council of a state, having such a council, or for the creation of such a council in a state having no such council, if the Legislative Assembly of the state passes a resolution to that effect by a majority of the total membership of the Assembly and 2/3, my lord, of those present and voting. In our case, my lord, the Legislative Council is gone. Well, actually, the whole of the JK Constitution is impliedly gone. Where was the power to do away with that? But that's another question that I'll come to, my lord. Then, my lord, kindly come to Article 239. I had earlier said, my lord, the other day, that most of the union territories, other than Chandigarh, were created by constitutional amendment, or under the aegis of a constitutional amendment like the 6th Amendment. (239A), my lord, deals with how union territories are to be created and the creation of local legislatures. This can't be given the go-by, my lord. Parliament may by law create for the union territory of Puducherry a body elected partly or partly nominated, partly elected to function as a legislature and a council of ministers, or both with such constitution, powers and functions in each case as may be specified. Now, my lord, compare with what has happened in the case of J&K. State has become union territory, my lord. 2 union territories, one without a legislature, one with. This was not within the remit of Article 3 and 4 as an incidental provision, my lord, where you lose your character as a state, and there are 2 union territories that have been created not by reference to Article 239A or 239AA. If you wanted an elaborate constitution put in place, as in the JK Reorganization Act, you should have done what is done with Delhi. The council disappeared. Now, my lord, your lordships are very familiar with the 2 Delhi judgments, my lord. I'm going to refer to passages of it because they deal with diversity. But when I read my written submissions, my lord, they'll be there. I won't have to ask your lordships to PDF. Now, my lord, come to Article 240. Power of the president to make regulations for certain union territories. Puducherry is mentioned, my lord, as E. Do we add JK, my lord, and Ladakh to it? Because if 240 is applied to JK, as it must be, my lord, it's a union territory now. Or perhaps that has to be added by constitutional amendment. But, my lord, the president will make regulations for peace, progress, and good government of union territories. Is this applicable, my lord? If so, my lord, it undermines not just federalism, my lord, but democracy itself. Now, my lord, may I take your lordships to 243, particularly to 243M and 243ZC. Now, 243M says part of panchayat, so fundamental to three-tier federalism, shall not apply to certain areas. I'm just showing the diversity, my lord, that exists. Now, my lord, if your lordships will come to subclause 2(3)A, this will not apply to the district of Darjeeling of West Bengal, for which the Darjeeling Gorkha Council exists under any law for the time being in force. Even the panchayat amendments, my lord, have been curtailed in this balance of federalism. Not, my lord, by any executive exercise. And then, my lord, 3A, that it won't apply to Arunachal Pradesh. And then once again, my lord, here is a non-legislative function, my lord, in Article 4. Legislature of the state may by extend this part to the state except the areas referred to in clause 1. If the legislative assembly of that state passes a resolution to that effect by a majority of the total membership of the House and by a majority of not less than 2/3. Here is once again a provision, my lord, the most fundamental exercise of three-tier federalism, my lord, which is a part of our constitution. Then, my lord, ZC, 243 ZC, says the same thing, my lord, about the Darjeeling Gorkha Hill Council. First, my lord, 243 ZB, my lord, which is about municipalities. It applies to union territories which have a legislative assembly. What happens to Ladakh? (243 ZC, my lord, has similar provisions as regards municipalities as it does to panchayats. In relation to the Darjeeling Gorkha Hill Council. (275, my lord, very fast. Sorry, 244, my lord. This is, my lord, dealing with scheduled and tribal areas. None of this can be wished away, certainly not by executive action. It is so crucial to understand this diversity of our constitution. 244 says, administration of scheduled areas and tribal areas shall apply to the administration and control of scheduled areas in any state other than the states of Assam, Meghalaya, Tripura, and Mizoram. And then 244A is a very important provision, my lord, because it relates to autonomous states. Our constitution, my lord, doesn't shy away from creating autonomous states, my lord. In fact, it reinforces them. And if there was that measure of autonomy, my lord, in JK, then it is not inconsistent with so many provisions in our constitution which respect autonomy for what it's worth in special areas.
244A, my lord, is very important. And when I come to Schedule 6, because if this can be done, my lord, under President's rule, place any under President's rule, expand it beyond the legislative function. Simply can't be done, my lord. These are mandatory provisions of the Constitution. 244A, formation of an autonomous state concerning tribal areas in Assam and the creation of local legislative councilmen. Parliament may by law, from within the estate of Assam, an autonomous state comprising whether wholly in part of tribal areas. Autonomy, my lord, of the states is fundamental to our Constitution. I rely on the two daily judgments, my lord, of your lordships to reinforce this. Where your lordship respected, my lord, the autonomy of the legislatures and their existence. Those passages I'll show to your lordships very fast, my lord, because they're in my written submissions. Autonomy, my lord, is not alien to our Constitution. You can't just standardize, my lord, all the provisions and say, look, we give autonomy here, but we're not going to give autonomy to J&K. Why? Because on 19th December, we took away a provision. J&K is not a dead horse, my lord, to be flogged or not to be flogged. It is the constitution of an autonomous region through the merger agreements which are part of 370. I'll come to 370 in a moment. It's very important to understand and not wish away the autonomy in Indian federalism. Then, my lord, if I may take your lordships, my lord, to 275. It has special provisions, my lord, made in 275, subclause 1A. Check with it. Can I tell them you are my guru? Now, my lord, kindly see what happens to the disbursement of grants to autonomous states in 275 1A. Next, my lord, 279A, which is the GST amendment. I put it in summary form, my lord, in the table so that it will be a little easier for your lordships. Even in the distribution, my lord, as far as the GST applies, 279A subclause 4G says special provision, I'm sorry, my lord, where I put in my chart 279, it should say 279A. Now, my lord, 4G is a very interesting proposition. Special provision meant to be made to the states of Arunachal, Assam, Jammu and Kashmir, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, Tripura, Himachal Pradesh, and Uttarakhand.
This must be on account of geographical reasons.
Sorry, my lord?
This must be on account of geographical reasons. All these are hilly states.
Partly that and partly because of the nature of the states. Your lordship is right, now. But this can be reversed and it will be placed before the GST because it lays later on that the GST Council will look at this. Now, my lord, I come to Article 330. Very important provision, my lord. To say that special provisions can't be made in the Constitution is anathema, my lord. Now, my lord, these special provisions relate to certain classes. Scheduled caste, scheduled tribe, Anglo-Indians, etc. Special provisions are a regular feature of our Constitution. I don't want to take your lordships through this, but these special provisions exist, without which, my lord, so much could not be done for the SC, ST or the OBCs. In fact, all these commissions, my lord, they report. And when the government of the state, it has a very interesting provision that it shall be laid before the legislature of the state, explaining with a memorandum the action taken or proposed to be taken on the recommendations relating to the state reasons for the non-acceptance. This is, my lord, 338(7). This is what should be done with President's rule, my lord. Even the governor's report, my lord, was not placed. This is what has to be written in, just as your lordship in Nagaraj added conditionalities, my lord. This is what should be written into 356. You put in all the information you have, you put in the governor's report, and you give the reasons for the non-acceptance. This runs for the other commissions as well. Otherwise, my lord, 356 has become a farce. When I was doing my book on President's rule, my lord, the elaborate discussion on Kerala, my lord, when President's rule was imposed. As we come down the line, there is hardly any discussion in Parliament. Why? Because all the information is not even there. And in the case, my lord, of Jammu and Kashmir, it wasn't there. The entire correspondence, my lord. I'm just building, my lord, something that is here in 338(7), which is also for the other commissions, my lord. Something, my lord, that gives information to the people and those people who have to, Parliament that has to bless or unbless, as the case may be, my lord, President's rule. That entire cache of information, which is so fundamental, my lord, to democracy and federalism, is missing in the proclamations. Then, my lord, if I may take my lords, my lord, to an interesting provision, my lord, 330, my lord, which makes special provision for reservation of scheduled castes and scheduled tribes. Sorry?
We saw 330. We've seen 330.
Assam is mentioned, you've done that. 343, my lord. This has to be read with the 8th schedule. Kashmiri, my lord, is one of the languages recognized by the 8th schedule. Kindly just bear this in mind. So in communications, in complaints, etc., Kashmiri can be used. That has not been taken away and cannot be taken away. Part of the spirit, my lord, of a region or a state is its language. Now, my lord, your lordships, when you look at the language of the Union, a commission is appointed. (347) makes special provisions for language spoken by a section of the population. And of course, my lord, chapter 4, that's 350,
has special directives in relation to language. Who is going to make those special directives now? The President? Parliament? What is the status of Kashmiri now, my lord? Does it disappear from the 8th schedule, my lord? Then, my lord, 371A, my lord, has a very interesting provision. 368, my lord, I've kind of dealt with, my lord. So I won't take your lordships to that. But 371A, my lord. It is a very interesting provision, my lord. With all this discussion on the Uniform Civil Code, these are also unamendable provisions, my lord. Just as we are arguing that 370 was unamendable, my lord, by 368, subject to a certain procedure. (371A) says, notwithstanding anything in this constitution, no act of parliament in respect of the religious and social practices of the Nagas, Naga customary law and procedure, administration of civil and criminal justice involving decisions according to Naga customary law, shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. Non-legislative power. And the same is repeated, my lord. The important provision, my lord, in 371, of course, concerns the hill areas of Manipur, very relevant. My learned friend has a point that if there is President's rule, the Legislative Assembly has this power. Can Parliament exercise it, my lord? That is why, my lord, it is restrained in 356. Now, my lord, the controversial provision in which your lordship has given a judgment is 371F, capital F, subclause F. This is Podial, my lord. If I have time, my lord, I'll take your lordship. So if not, my lord, I'll just refer to paragraphs. Parliament, for the purpose of protecting the rights and interests of different sections of the population of Sikkim, may make provisions for the number of seats in the Legislative Assembly of the state of Sikkim, which may be filled by candidates belonging to such sections for the delimitation of the Assembly constituencies, from which candidates belonging to such sections alone may stand for election to the Legislative Assembly. This, my lord, was examined in Podia. I'll give your lordships the reference, my lord. Podia, which volume is it in? It's in volume 14, my lord. The argument was a very interesting argument, my lord. Baba Sahib Ambedkar itself said in Parliament that there will be one person, one vote, apart from the reservations from SC, ST, etc. So the argument that was advanced, my lord, which led to a 3-2 decision, was that although this is their part of the constitution, we have to take the history of Sikkim into account, and reservations for Bhutias, Lepchas, and the Sangh are permissible. This, your lordships, my lord, will find in volume 14, 6350. The majority starts at 6392, my lord. Mandatory provisions respecting, my lord, what the people of Sikkim had asked for. Albeit, my lord, with adjustments to the constitution. Now, my lord, while you're on it, will your lordship just turn to Cordial, my lord, because it's important to bear in mind. PDF क्या है? 305. Volume 14, 305. Starts it, sorry.
Volume 14, page
Cases volume.
30.
305. My lord, if your lordships will turn to 6394, my lord, which is PDF 349.
Where does it actually begin, the judgment? Ah, yes, I got it.
Sorry, my lord.
It begins at 305.
Where it starts, my lord.
Yes.
And I'm referring to the discussion in Chief Justice Venkatachalaiya's judgment, my lord. At PDF 349. I'm on 36394, which is PDF 249, 349. Now, my lord, here, I'll go through it very, very quickly. Just the learned Chief Justice, my lord, goes from para 66 onwards to all the proclamations and discussions till para 76, my lord. '74 in particular, my lord, at page 6396. The year 1973 saw the culmination of a series of successive political movements in Kashmir towards the government responsible to the people. Then it mentions the tripartite agreement, clause 5 of which is mentioned there in para 74. And various other provisions are made. Welfare. Where he actually deals with where he actually says, just give me a moment. Oh, they are. At para 120, Lord.
Of the judgment?
PDF 364. Why was this not promised to the people honored despite a provision of the Constitution? And this is explained by the majority at para 120.6409. PDF 364. Para 120. What was the rationale, my lord, of respecting what the people of Sikkim wanted, despite the provision in this constitution, one person, one vote, and no vote on account of religion? The rationale and constitutionality of Clause F and other provisions of the electoral laws impugned in these petitions are sought to be justified by the respondents on grounds that a perfect arithmetical equality or value of votes is not constitutionally mandated, imperative of democracy. And second, even if the impugned provisions make a departure from tolerance limits and the constitutional permissible limits, the discriminations arise are justiciable on the basis of the historical conditions peculiar to and characteristic of the evolution of Sikkim's political institutions.
and the characteristic of the evolution of Sikkim's political institution. Therefore, my lord, your lordship, as we've taken into the discussions that were held as far as J&K was concerned. And why it is important, my lord, particularly as I indicated, the merger agreement, which deals with internal sovereignty. Unlike, my lord, the instrument of accession, which deals with external sovereignty. Then, my lord, the last 4 lines are important. What Article of 120, 371 FF, and the electoral laws in relation to Sikkim seek to provide, it is urged, is to maintain this balance in the peculiar historical setting of the development of Sikkim and its political institution. Sikkim is the only other example we have other than Kashmir, where it was entered into one. And therefore, you take into account all the antecedent discussions and see if they make out a case, whether for 370 or otherwise. In my voice. Put some whiskey in it. Now, my lords, I take your lordships, my lord, to Schedule 5. I'll skip, my lord, the in the Constitution. Okay. Schedule 5, my lord, deals with the administration of scheduled areas and scheduled tribes. Some of us are not happy with the Constitution Bench decision in Chebrulu, my lord, on how you apply legislative powers. But, my lord, there's a Tribals Advisory Council. So when the governor, my lord, applies laws under 5 subclause 2, subclause 5 says no regulation under this paragraph unless the governor making the regulation has, in the case where there is a Tribal Advisory Council, consulted such council.
Where is that, Dr. Dhawan?
My lord, this is in subpara 5, my lord.
Okay.
5.5, my lord.
Consultation with the Tribes Advisory Council.
Now here, my lord, even where there is power, you must consult the Tribal Advisory Council. Then, my lord, I come to the most important article on schedule on autonomy, Schedule 5. 6. My learned friend rightly points out that Schedule 5, my lord, deals with Assam, Meghalaya, Tripura, and Mizoram, excludes them, and then this, my lord, is applied in Schedule 6.
Now, my lord, we come to the question of autonomy of the Northeast, my lord. My lord, without all these autonomies, my lord, India would have collapsed by now. Because unless all this was given, my lord, to the states in question in the light of antecedent discussions, my lord, this quest for uniformity across the board, which 272 and 273 seem to countenance, my lord, is not the heart and soul of the Indian Constitution. It is autonomy within federations, special provisions in relation to people. Take that away, my lord, we don't need such a big constitution. And all the antecedent discussions, my lord, become part of these autonomies and special provisions. We can't wish them away, my lord, and say they are just history. Okay. So far, so good. Now, my lord, kindly come to Schedule 6. There is, my lord, apart from the ones that are dealt in Schedule 5, as my learned friend pointed out, this applies to tribal areas in Assam, Meghalaya, Tripura, and Mizoram. And subpara 1, my lord, is headed Autonomous Districts and Autonomous Regions. They have an in-between status between panchayats, my lord, and union territories. Now, my lord, under Article 1, Subclause 3, the governor, no doubt, my lord, with the advice of his Council of Ministers, wherever we read governor, my lord, it is rarely in his personal capacity. Apart from death penalty cases from which your lordships have ruled. The governor may, by public notification, include any area in any of the parts of the said table, exclude any area in any of the parts of the said table, create a new autonomous district, increase the area of any autonomous district, diminish the area of any autonomous district, unite two or more autonomous districts or parts thereof so as to form a autonomous district, alter the name of any autonomous district, define the boundaries of any autonomous district. This is a little akin, my lord, to Article 3. And this is where the entire politics of the Northeast, my lord, and the provisions, my lord, relating to the Northeast arise. Gorkhas say we want Gorkha land. Somebody says I want Bodo land. All this, my lord, emanates from Schedule 5, 6 and the concept of autonomy. Then, my lord, subpara 2, there shall be a district council for each autonomous district consisting of not so many members, of which 4 will be nominated by the governor. And then, my lord, there shall be a separate regional council for each area constituted an autonomous region under subpara 2. Subpara 2 of each district and regional council shall be a body corporate with its seal, etc. What is important, my lord, is also what do these autonomous councils do? Kindly come to paragraph 3.
powers of the district and regional councils to make laws. Has your lordship got it?
Schedule 6. Schedule 6.
To each of these is given a lawmaking power, with of course some limits, without which we might lose the Northeast. My lord. It is this democratization, my lord, of power that has enabled, my lord, us to make special concessions where they are necessary. Given the antecedent history, as I've explained in the case of Sikkim. Then, my lord, the regional councils, district councils and regional councils to make laws. And then, my lord, there are a series Now, my lord, there are two interesting provisions, my lord, which your lordships will probably find in the footnote to the sixth schedule. That is an article, my lord, a subpara 3A. Wasn't without, my lord, protest and accommodation. Has your lordship got 3A, my lord, somewhere in the, probably in the footnote?
Yes.
Additional powers of North Kachar Hills Autonomous Council and Karbi Anglong Autonomous Council to make laws. And this includes, my lord, subject to the provisions, of course, of List 1, 7, and 52. Which interesting part, as my learned friend points out, in 371, 3AB, communication, my lord, is given to the, it says to the councils, that is to say roads, bridges, ferries, and other means of communication not specified in List 1 of Schedule 7. Now, my lord, come to 3B. Your lordships are familiar, my lord, with the Bodoland, my lord, agitation. I needn't explore that further, although we have material on it. 3B says additional powers of the Bodoland Territorial Council to make laws. And then lists on what they can make laws. Paragraph 4, my lord. I'm almost done, but not with this diversification point, my lord. Now come to paragraph 4, administration of justice in autonomous districts and autonomous regions. Which goes on to then say, may appoint suitable persons to be members of such village councils and presiding officers of such courts. It's a little lower down, my lord, in that paragraph.
Which is the next clause?
No,
Para 4, you were saying.
I was taking your lordships to para 4, my lord.
That's the administration of justice.
That's the administration of justice. Of course, my lord, sub-para 3 says the High Court shall exercise jurisdiction over the suits and cases to which provisions of sub-para 2 of this paragraph
Yes.
apply, as the governor may for time to time specify. Even as regards the High Court.
Yes, Doctor.
Then, my lord, 121, para 12 and 12A. 12A and 12AA, my lord, I want to point out how in the state of Meghalaya and Tripura, my lord, autonomous districts have laws which are subject to what is equivalent to the 254 procedure. And your lordships will see in 12A, notwithstanding anything in the Constitution. Likewise, my lord, 12AA, notwithstanding anything in the Constitution. Then 12B from Mizoram, my lord, notwithstanding anything in this Constitution. It limits even the powers of the legislature.
Oh, yeah.
President's rule, where is it? No, on 370s.
Okay, we have.
Lord, the reason why I've cited all this, my lord, is because of the diversity this constitution, my lord, makes in federalism and democracy. A diversity that is to be treasured, not wished away in the name of uniformity. There are no dead horses to be flogged.
Diversity, I mean, you are right, it's possibly more diverse than the whole of Europe combined together.
Europe, America, Sub-Saharan Africa, take parts of the South Seas. This is, and so is Jammu and Kashmir, my lord, with its history. It has its own diversities. Diversity is necessitated because of the absence of the merger agreement, my lord. So what I'm going to call this, although, my lord, in my submission I've called these asymmetrical provisions, these are in fact multi-symmetrical provisions. This makes our constitution unlike any other in the world. Simple examples of asymmetry are Canada. You will have French in one area and English in the other. Or Belgium, the three-language formula. Those are asymmetrical. The Indian constitution is multi-symmetrical, of which J&K is a part. For its reasons, I'll now come, my lord, straight away to 370. Much of it has been argued, so I don't have to take your lordship through all of it, my lord.
Point after lunch that.
I'm sorry I've taken some time, my lord, because as soon as your lordship asks for a list, as you asked Mr. Zafar Shah, your lordship said, you've done with point 6, now what's come to the other one? I have a list which I'll get to your lordship after lunch.
Dr. Dhawan, how long would you now take after lunch so that the next
An
person?
hour or so, if possible, my lord.
Could we cut it, possibly curtail it to about half an hour after lunch? Half an hour after lunch, can we conclude it? Maybe.
May not be enough now. Just give me that, my lord.
All right, 45 minutes. 2:45, we'll move on to the
My
next.
lord usually arrive late, my lord. That knocks off 10 minutes.
That's why I said 45 minutes. We didn't say 2:45. But we'll be here at 2 o'clock.
Sure.
Check. Hello, check 1, 2. Hello, check 1, 2.
Lordship has not eaten into my time.
Absolutely not. 2:55.
No, my lord. There's Mr. Dinesh Dwivedi's time, my lord. He took my time on technical incompetence, as I did on libraries. All that has to be adjusted. I'll do my best, my lord. I'll do my best. Because what I've done now, my lord, as I put census summary at the end, which I'll hand over like Mr. Zafar Shah did. But what I can't resist, my lord, on the diversity argument, a passage from TMA Pi, which is not in your lordship's compilation. So I've made copies. May I hand them over? Give to the other side also. Lord, I'll take your lordship straight away to para 157, which is on page 586. And just below placetum D. This is the most evocative understanding of the diversity of our constitution, apart from the two Delhi judgments which went into it in depth. Now, just below placetum D, Lord, may I just read?
Yes.
All the people of India are not alike. And that is why preferential treatment to a special section of society is not frowned upon. Article 30 is a special right conferred on the religious and linguistic minorities because of their numerical handicap and to instill in them a sense of security and confidence, even though the minorities cannot per se be regarded as weaker sections or underprivileged sections. Now, 158 is the evocative passage that I want to read. The 1 billion population of India consisting of 6 main ethnic groups, 52 major tribes, 6 major religions, 6,400 castes and subcastes, 18 major languages, and 1,600 minor languages and dialects. The essence of secularism can best be depicted if a relief map of India is made in mosaic, where the aforesaid 1 billion people are the small pieces of marble that go into the making of the map. Each person, whatever his, her language, caste, religion, has his or her individual identity, which has to be preserved, so that when pieced together, it goes to form a depiction with the different geographical features of India. These small pieces of marble in the form of human beings, which may be individually be dissimilar to each other, when placed together in a systematic manner, produce the beautiful map of India. Each piece, like a citizen of India, plays an important part in the making of the whole. The variations of the color as well as the different shades of the same color in a map are the result of these small pieces of different shades and colors. But even when one small piece of marble is removed, the whole map of India would be scarred and the beauty lost. Just over the page, my lord. Each of the people of India has an important place in the formation of a nation. Each piece has to retain its color. By itself, it may be an insignificant stone, but when placed in a proper manner, going into the making of a full picture of India in all its different colors and hues. A citizen of India stands in a similar position. The Constitution recognizes the differences amongst the people of India, but it gives equal importance to each of them, their differences notwithstanding, for only then can there be a unified secular nation. Recognizing the need for the preservation and retention of different pieces that go into the making of the nation, the Constitution, while maintaining inter alia the basic principles of equality, contain adequate provisions that ensure the preservation of these different pieces. I wanted to read this, my lord. It's a very evocative passage, my lord. Now, my lord,
Yes.
your lordship will be dealing with pieces of marble, my lord. How you deal with it, my lord, will come later. Now, my lord, may I invite my lords, my lord, to my submissions,
Yes.
which is in volume 1, page 195, PDF 195. I'm going to go at super speed, my lord, because there's a guillotine on my head, my lord. Very sharp one, I might add. Now, my lord, I'll just take your lordship very quickly. Come to the 198, my lord, page, the external, your lordship's page. Skip all that, my lord, and come to page 200, which is
Again,
PDF.
I'm not able to get.
Which file are you?
Volume 1 of the written submissions, my lord.
There's a WC. Yes, yes. Yes. Oh, I see.
I'm sorry, my lord.
190.
Your is the
PDF page 195.
Page 195, where it starts, my lord.
195 to
There
280.
is an index which I won't trouble your lordships with, my lord,
is volume 2.
but I'll take volume 1.
Volume 1.
Volume 2 was Mr. Sybil's submission, which came, my lord, a few days late.
200 पे नहीं आ रहा है, वो 00 पे आ जाता है। नहीं, volume 1 पे है।
But at 200. Your lordships have it, my lord?
Yes.
Yes.
I'm taking your lordships on PDF 200 in para 1.5, because all the other documents have been read. I'm not going to repeat them. The history has been shown to your lordships. But I made a point, my lord, about why the merger agreement was important and why 370 in one sense represents the standstill and merger agreements. I'm going to read this passage, my lord, from Premnath Kaur in para 1.5. Has your lordship got it?
Yes.
Referring to the past, my lord, thus there can be no doubt that this act of 1939 marked the second step taken by the Highness in associating his subjects with the administration of the state. It did not constitute even a partial surrender of his Highness of his sovereign rights in favor of the Rajya Sabha. Even after the instrument of accession, my lord, he had not given up his rights. That, your lordship, will come over the page. I can give the PDF numbers to this if your lordship wants, my lord, but it's in.
No, we've got it.
Now, my lord, dealing with after the instrument of accession.
How many judges was Premnath called?
5.
No, it's. Yes, 5 judges. These are all constitution benches. Now, my lord, may I take your lordships to 1.7?
This is in relationship in regard to the relationship of these of the Maharaja with the Praja Sabha.
This is Praja Sabha, my
Praja
lord.
Sabha.
I'm now building on that, my lord.
Yes.
Therefore, my lord, what actually 370 represents is two powerful democratic movements, my lord. One in the people of India, my lord, and the other, my lord, in the people of Kashmir, demanding of their Maharaja, which is eventually what he did. He gave a Praj Sabha, he wanted a National Assembly, but he didn't agree to a Constituent Assembly, which came later, my lord. Now, my lord, 1.7. Maharaja Hari Singh continued to be the absolute monarch of the state, and in the eyes of international law, he might conceivably have claimed the status of a sovereign and independent state. Because all the instrument of accession did is put in these four conditions and said externally, my lord. That's why I made the distinction between external sovereignty and internal sovereignty.
This is with reference to 15, date is 15th August 1947, not with reference to the.
I'm coming, my lord, to the instrument of accession, my lord, in 1.8.
That's 1.9.
That's right, my lord, that's the instrument of accession. Immediately after that comes 1.10. Thus, by the instrument of accession, the Maharaja took the very important step of recognizing the fact that his state was a part of the dominion of India. That's all that the instrument of accession represented. We can't say at that point that he had surrendered all his sovereignty. He had not, my lord. That process began partly politically because of the political movement and partly because of 370, my lord. Because that's where we see a coming together of the Constituent Assembly, the governor, the president, all that comes together because there was no merger or standstill agreement. Now, I won't read, my lord, the proclamation of the Maharaja, my lord, of 1948, where he talks of his Council of Ministers. I'll just come straight away, my lord, to what Sardar Patel said over the page in 1.13. In view of the special problems with which the government of Kashmir is faced, we have made a special provision for the continuance of the constitutional relationship of the state on the existing basis. And it's very important to understand what 370 really represented and what the instrument of accession really did. It bound itself to India, but the rest of the process of democratization, my lord, of adjustments, of sharing of power, was never done in the case of Jammu and Kashmir. Even in the white paper, my lord, on the states, there is one paragraph which says, we are not dealing with Jammu and Kashmir. Then, my lord, your lordships will just come to 1.21. On the 12th of November, pursuant to a resolution of the Constituent Assembly resolving to end hereditary rulership in the state, Yuvraj Karan Singh was elected to the post of so-and-so, and dynastic rule in J&K came to an end. Now, your lordships have already been shown how CO 48 emanated from the Assembly of Jammu and Kashmir, Constituent Assembly, and became part of our constitution. This part, my lord, of your lordships, I needn't give you cross references, need I, my lord? PDF.
No, neither. No, that's
now, my lord, I'll skip the rest. 1.24, my lord, I've already read the second proviso to Article 3.
Yes, we saw.
So I won't read it again, my lord. But I come, my lord, to page 11, 1.30. Before that, my lord, just
Dr. Dhawan, just
1.25.
one thing, just more for your juniors than for you. The dates which you have given in the written submissions, if anything is missing in Mr. Sibbal's list of dates, perhaps it might be good if we have it in one place. Likewise, when the respondents begin, it would be very nice, if we have one consolidated list of dates so that we don't have to, sort of then
That's right.
shuffle between two or three
Showing
different.
Mr. Sibbal's list of dates in a separate font or separate color or something.
And
Well,
something
but
which you're adding, because I think we were reading Mr. Sibbal's list of days, there's no innuendo in any of the lists. It's just state the date. So if you feel that, there's something missed out, then you can make track changes in that list of dates. So it'll be a little easier for us ultimately after the ability, isn't it, Sandeep?
My lord, what I'm endeavoring to do, my lord, substance to the list of
All right,
dates.
fair
This
enough.
is what I'm trying to do.
Fair enough. Then there's not.
Not just reading it as a list of dates.
Fair enough.
Now, 1.25, my lord. (1.25), my lord, on the 17th of October 1956, the Constitution of Jammu and Kashmir was adopted by the JK Assembly. All the details are given there, my lord.
Yes.
Now, my lord, this is a singular aspect of Indian federalism, to have a separate constitution for a state. For others, you gave autonomous regions, you bound them together, you expanded it. But this, can the JK Constitution of 1957 be wished away by an amendment to CO2 272, 273 and Article 3? It simply can't, my lord. So one of the big losses is, where has it? It's like Macbeth, the Thane of Fife, he had a wife, where is she now? JK had a constitution, where is it now? Has it been subsumed by 273? And when I go to 273, my lord, I'll deal with that. Now, my lord, I come to asymmetrical federalism at 1.30. Kindly change that to multi-symmetrical, as I've argued, my lord. Now, my lord, all those references are there. But, and of course, I've given your lordship a list, which I don't want, which is not repeated here. So I'll come straight away to 1.33. The importance of the Delhi decisions, my lord. I'll take up the second decision first. The Chief Justice, after reviewing the asymmetrical provisions described above in State of Delhi so-and-so in 2023, held that regard must be had to the principles of asymmetrical federalism embodied in the Indian Constitution, and that constitutional principle must be given substantive weight to this underlying principle. I'll read that paragraph. Actually, I should read it at the end, but I'll read it now. This variance in the constitutional treatment of union territories, as well as the absence of a homogeneous class, is not unique only to union territories. The Constitution is replete with instances of special arrangements being made to accommodate the specific regional needs of states in specific areas. Therefore, NCTT is not the first territory which has received special treatment through a constitutional provision. But it is another example in line with the practice of the Constitution and visiting arrangements which treat federal units differently from each other to account for their specific circumstances. For instance, Article 371 of the Constitution contains special provisions for certain areas of various states, as well as the entirety of some states. The marginal notes to these articles, composed of rubric of 371, provide an overview of a number of states where arrangements in the nature of asymmetrical federalism are made in the spirit of accommodating the difference and specific requirements of regions across the nation. The next, my lord, line, para 41. I'm not taking your lordships to the PDS, my lord, because this is enough of what I want to refer to. The design of our Constitution is such that it accommodates the interests of different regions while providing a larger constitutional umbrella to different states and union territories. It preserves the local aspirations of different regions. Unity in diversity is not only used in
common parlance, but is also embedded in our constitutional structure. Our interpretation of the Constitution must give substantive weight to the underlying principles. This is, my Lord, how we approach the Constitution, as has been done otherwise also. Now, my Lord, I add to this, my Lord, the huge number of precedents, my Lord, of what is called transformative constitutionalism. 1.36. The ultimate goal, that's from Navtej Singh Johar, of our magnificent constitution is to make right the upheaval which existed in Indian society before the adopting of the constitution. The court in so-and-so observed that the Indian constitution is a great social document, almost revolutionary in its aim of transforming a medieval hierarchical society into a modern egalitarian democracy, and its provisions can only be comprehended only by a spacious social science approach, not a pedantic traditional legalism. The whole idea of having a constitution is to guide the nation towards a resplendent future. Therefore, the purpose of having a constitution is to transform the society for the better, and this objective is for the fundamental pillar of transformative constitutionalism. Then, my Lord, the Chief Justice, as he then was, my Lord, in the 219 decision, my Lord, of the Delhi decision, the Constitution is a transformative document. The realization of this transformative potential rests ultimately in the ability to breathe life and meaning into its abstract concepts. For above all, the Constitution was not intended by its draft persons, by its draft persons to be a significant instrument of bringing about social change in a caste-based feudal society witnessed by centuries of oppression and discrimination against the marginalized. As our constitutional jurisprudence has evolved, the realization of the transformative potential of the Constitution has been founded on the evolution of equality away from its formal underpinnings to its substantial potential. My Lord, I cite this for a reason, my Lord. When this hearing began, my Lord, it appeared to me that we were reading the Constitution as if it was a statute. For a long time, my Lord, we were going to this word and this proviso and that proviso, my Lord. That is not how constitutions were meant to be read or to be transformed. Then, my Lord, if your Lordship will come to this question 1.41, I won't read it, my Lord, because constitutional morality is also mentioned, my Lord, in various judgments of my Lord the Chief Justice when you refer to Pratap Bhanu Mehta's contribution, etc., my Lord. Now, my Lord, straight of NCT versus Union of India, if the moral values of our Constitution were not upheld at every stage, the text of the Constitution may not be enough to protect its democratic values. In order to truly understand what constitutional morality reflects, it is necessary to answer what is that Constitution trying to say, and to identify the broadest possible range to fix the meaning of the text. Constitutional morality does not mean allegiance to the substantive provisions and principles of the Constitution. It signifies a constitutional culture which each individual in a democracy must imbibe. Pratap Bhanu Mehta identifies certain features of constitutional morality, chief amongst them being liberal values which govern the making of India's constitution, and created expectations from the polity. One of the essential features of constitutional morality, thus, is the ability and commitment to arrive at decisions on important issues consensually. It requires, despite all differences, we are part of a deliberative exercise. It is going to be my submission, my Lord, that this deliberative exercise, my Lord, has not taken place with the changes of the J&K Constitution. Now, Mr. Sibal, my Lord, had a number of questions that were asked in Parliament till the last day. Your Lordship has seen that. Are you changing 370? The answer was no, no, no. And suddenly, my Lord, out of the blue, we entered into 5th August. This, my Lord, consultation or concurrence, my Lord, is fundamental to the manner in which we read constitutions and how each provision comes into place. Then, my lord, I will just read, my lord, the NCT decision. That's the earlier one, my lord. While interpreting the provisions of the Constitution, the safe and most sound approach for the Constitutional Court to adopt is to read the words of the Constitution in the light of the spirit of the Constitution, so that the quintessential democratic nature of our Constitution and the paradigm of representative participation by way of citizenry engagement are not annihilated. This court must adopt an interpretation which glorifies the democratic spirit of the Constitution. The Constitution has mandated a federal balance wherein the independence of a certain required degree is assured to the state governments. As opposed to centralism, a balanced federal structure mandates that the union does not usurp all the powers and the states enjoy freedom without any unsolicited interference from the central government with respect to matters while exclusively falling into its domain. So this is the approach, my lord, towards constitution to multi-symmetric federalism. Now, my lord, I will take your lordships straight away, my lord, to 370. I think at some stage a question fell from your lordships. Weren't any protests made before that, my lord? I just want to take your lordships to 2.15 at page 221 external. My lord, there is a literature that could fill a library on the protests over 370. And then, my lord, the State Autonomy Committee, my lord, read this out. And of course, it goes to a slightly further extreme, my lord. But this is, my lord, the constitutional understanding, which is not too dissimilar with other federations. I won't read it, my lord. I've just pointed it out to your lordships. Once again, my lord, I've reproduced here the debates. I'm not going to read those out, my lord. Iyengar's speech has been read out to your lordships, my lord, 2 or 3 times. It's just that on page 224, whatever I've highlighted